Hi, my name is Dr. Debaruti Haldar, and in this session, I'm going to discuss about victimology and Indian experience. We have seen that victimology is comparatively new than criminology. However, in this session, I'm going to discuss about how the Indian authors, Indian ancient codes, or the Indian system has influenced the growth of victimology and how the Indian system has influenced the victimology concept and how this is being used or how this is being made to execute through the Indian legal system in the present scenario. As we know, victimology as a subject has been developed by Benjamin Mendelssohn in 1947. Victimology, in its original form, actually comes from two words, victima, that is Latin, and logos, that is Greek, which means that science of victims. As such, victimology may be defined as the study of the causation of victimization, its consequences and impact on the victims, and how different stakeholders, that is, the police, courts, media, etc., deal with it. Victimology basically differs from criminology in the sense that it doesn't study the causation of criminalization. On the other hand, it studies the causation of victimization and also the consequences of victimization and its impact on the victims. And further, how different stakeholders, that is, the police, courts, media, or the frontline professionals like the doctors, etc., they deal with the victimization of the victims. Victimology in India had existed since long. In fact, in our ancient texts, we get to see the existence of victims' rights. We know that victimology can be divided into three periods, that is, golden period of victimology, dark age of victimology, and contemporary world. In the golden period of victimology, we have seen the existence of the victim's rights in ancient codes like Manusmriti, Arthashastra, etc. Here, we get to see rights of the victims to get compensation has been recognized. At the same time, these codes also acknowledge the fact that strict punishments for bodily injuries, property crimes, etc., may provide a satisfaction to the victims as well as may prevent further victimization for the victims as well as for the entire society. It can be a very good example for the perpetrators, for the criminals, so that they may not go ahead for doing certain kinds of punishments which may victimize the other people. In the dark age of victimology, we get to see that victims have been reduced to the category of best witnesses. India has also seen this dark age, and in India, we also get to see from the ancient period to the medieval period, this categorization of the victims has been done. That means victims have been lowered to the category of the best witnesses. written laws, influence of right-based restorative justice over the rights of the victims, etc., had contributed significantly to this understanding that victims are the best witnesses. During this time also, we get to see that the state has emerged as the primary victim and the actual victims have been considered as the secondary victims. However, during this dark age of victimology, we also get to see that victims have been compensated, whereas punishment has been given to the criminals, and the state as the victims have been categorized as the best victims or as the primary victims while the cases have been dealt with by the courts. In the contemporary world, we get to see that victims have remained as the best witnesses. But due to the influence of the colonial laws, we have also seen that the restorative justice aspects for the victims have slowly started gaining back its importance, just like how we got to see in the golden period of victimology. But the process is very slow. However, in the contemporary world, we also get to see several other factors which have influenced the concept of victimology to be incorporated in the general criminal cases or general criminal procedural laws. These factors may include partiality to race, color, gender of the victims, etc. And that is the reason we get to see that the categorization of the victims as best witnesses have also been influenced, have also been impacted upon. Hence, we do get to see that the actual victims may not get proper justice. However, we cannot deny the existence and also the influence of documents, international documents like Universal Declaration of Human Rights, etc., or the international documents for the victims' rights. Hence, we are getting to see equal treatment of the victims are coming up, or equal treatment of the victims is also gaining proper attention, but again it is very slow process. However, there exists differentiation. But from this, what we learn? In ancient Indian understanding, victims' rights had been recognized. Restoration of justice had been recognized. The concept of victimology was there in our ancient texts. That means the ancient texts could study the causation of victimization, the impact of victimization, how the stakeholders, that is the king, the state, the criminal justice system, etc., would deal with such impact of the victimization, especially with the victims, etc., have also been discussed in the ancient texts. Further, speaking about the present context of victimology from the Indian aspect, we get to see the status of the victim have been to a certain extent influenced by the international documents as well as by the existing colonial law which has been rather Indianized since our independence. Hence, what we get to see, even though there are no special law for victim protection, there had been certain provisions that has been inserted in our present procedural laws. For example, insertion of section 2W in Criminal Procedural Code in 2009 about definition of victim has hugely impacted on the status of the victim in Indian criminal justice system. This has properly recognized the concept of victim, and this has also played a very significant role for compensation for the victims, primary victims, as well as treatment of the primary and also secondary victims. Further, in case of development of law and criminal justice system, we get to see there is a gradual development of the understanding of the victims from different right-based perspective. How is it? For example, we have got to see there is a huge growth in the understanding of child rights, in the understanding of women's rights, in the understanding of human rights from different perspectives. For example, disabled people's rights, minority people's rights, riot victims' rights, or for example, victims of conflict zone, victims of war, victims of property crime, etc. This is also growing. Introduction of the statutes to protect escalation of victimization of vulnerable victims, therefore, have also played a very significant role in preventing victimization and also looking after the impact of victimization so that such impact does not play a havoc role in the lives of the victims. Therefore, we also get to see introduction of Witness Protection Bill. However, this Witness Protection Bill has not yet been considered as a full-fledged statute. If this becomes a full-fledged statute, then it is expected that it will give more protection to the victims as best witnesses, also to the actual witnesses, and also it may help the victims to get proper justice. Further, we also get to see there is a huge development in the understanding of compensatory jurisprudence. As such, we are getting to see children victims, that is the child victims. They are also getting proper understanding for compensatory jurisprudence. Disabled victims, how to compensate these victims. These have also been looked after by the Indian criminal justice system. Further, we are also getting to see the concepts of rehabilitation, reintegration of the victims in the criminal justice system is also gaining attention from the lawmakers and also from the executors of law. These have been formed as part of certain statutes, especially for vulnerable victims. Therefore, we get to see rehabilitation, reintegration of children in need of care and protection, and also considering certain children who are in conflict with law as child in need of care and protection have also been given a very significant approach from the criminal justice machinery in India. Women victims who may have been victimized due to sexual assault, due to domestic violence, etc., are also being brought under the broader perspective of rehabilitation and reintegration in the society. Especially when we talk about the vulnerable victims, consider women victims who may have been considered as offenders of petty crimes, etc., if they are taken into a correctional administrative system, reintegration, rehabilitation of such victims have also been considered to a great extent. Special care for child in need of care and protection, child in conflict with law, victims of property crimes, irrespective of the gender, victims of bodily injury irrespective of the gender, also victims who may have caused or who may have undergone victimization due to certain situations like, as I mentioned, war, domestic violence, etc., they have also been considered as eligible victims to get the rehabilitation, reintegration. Consider the acid attack victims. The Criminal Procedure Code provides immediate medical help and also immediate legal help for such victims. Again, consider the motor vehicle accident cases. In cases where the victim has died, actual victim has died, the mechanism now sees that the deceased's children, especially minor children, should be looked after. Further, consider cases where children have become orphaned by pandemic, especially COVID-19. They are also being considered as victims of the situation, and the state is considering them as victims who are eligible for rehabilitation, reintegration, and also support from the state mechanism. One of the very important aspects of considering victimology within the criminal justice system in India is introduction of the concept of victim impact statement for considering victim compensation. Victim impact statement is a comparatively new understanding that is now being considered by the courts in India as well as by different courts from different jurisdictions. Earlier, in the colonial system also, we do get to see that the victim impact statement, especially from the victims from India or from the Indian victims, native victims, had been considered as a very neglected issue. But victim impact statement had been considered as a very significant factor in giving justice or providing justice for the victims in the golden age. In the case of Karan versus State of NCT of Delhi, this is a recent case, 2020 case, it was understood by the courts that victim impact statement is a must for considering the quantum of compensation. Why? Because victim impact statement would be indicating about the medical expenses that the victim had to undergo or has to undergo. The victim impact statement will also indicate about the situation of the victim, especially when the victim may lose his job, when the victim may undergo unemployment because of the victimization, or when the victim may undergo salary cuts, etc., because he has to regularly attend the courts or he has to go to the doctors, etc. Victim impact statement may also indicate about amount of the property loss, that is the quantum of the monetary aspect when some victim undergoes property loss. It also indicates about cost of legal procedures. Therefore, Current versus State of NCT of Delhi provides that victim impact statement should be considered when awarding compensation for the victims. Now, we also need to understand about the aspect that who pays for the medical expenses for acid attack victims. Does it come under the understanding of victimology in India? Now, there is a good development in this regard in the Indian system. Section 357A of the Criminal Procedure Code actually discusses about that. But this entire understanding comes from the UN Basic Principles of Victims of Crime and Abuse of Power, which states that when compensation is not fully available from the offender or other sources, state should endeavor to provide final compensation to the victims. It actually indicates about a state fund which may be used for compensating victims like the acid attack victims or the motor vehicle accident victims or the victims of natural calamity, etc. This is what has been also discussed under Section 357A of CRPC. The Indian understanding of payment of compensation under CRPC has been generally looked into or considered by Section 357 of the CRPC. It speaks about order to pay compensation. It says when a court imposes a sentence of fine or a sentence including a sentence of death of which fine forms a part, that means the sentence imprisonment sentence is also going on, plus the accused person, the convicted person, has to pay a fine also. The court may, when passing the judgment, order the whole or any part of the fine recovered to be applied in defraying the expenses properly incurred in the prosecution. In the payment to any person of compensation for any loss or injury caused by the offence, when compensation is, in the opinion of the court, recoverable by such person in a civil court. Now, this compensation, this section actually says, can be recovered by the state or by the court by different ways from the offender. And these actually indicate several other mechanisms that can be used, especially through civil courts also. Section 357A further goes ahead to say every state government, in coordination with the central government, shall prepare a scheme for providing funds for the purpose of compensation to the victims or his dependents who have suffered loss or injury as a result of the crime and who require rehabilitation. This indicates that the victims must be categorized on the impact of the victimization, on the gravity of the crime, so that the victims may be categorized as those victims who must get the compensation. Next, it also says whenever a recommendation is made by the court for compensation, the District Legal Services Authority or the State Legal Services Authority shall decide the quantum of the compensation to be awarded under the scheme referred to in subsection 1 of section 357A of CRPC. What does it mean? This actually says that it is the DLSA or SLSA that should decide the quantum of the compensation, and again this depends upon the victim impact statement, and also this depends upon the condition of the victim, the financial background of the victim, etc. Further, it says if the trial court at the conclusion of the trial is satisfied that the compensation is awarded under section 357 is not adequate for such rehabilitation, or where the cases end in acquittal or discharge and the victim has to be rehabilitated, it may make recommendation for compensation. This is something which completely depends upon the judicial discretion, and it actually says that if the accused is acquitted, discharged, or when the punishment has been given but it has been seen that the victim needs the rehabilitation, etc., and the victim may not be able to support himself. In such cases, compensation may be recommended by the courts. Further, it says where the offender is not traced or identified but the victim is identified, and where no trial takes place because there is no offender who can be found, the victim or his dependents may make an application to the state or the district legal services authority for award of compensation. Now, this is something which is very important especially for those victims whose offenders have fled from the region or from the country, but the victim has proved that he has been victimized due to the acts of the offender. Mostly in cases of motor vehicles cases, we get to see such kinds of incidences, or in cases of domestic violence cases, we may get to see such kinds of cases. Even in the property related cases also, we do get to see. However, we must understand that the burden of proof in all such cases depends on the victims largely. So in all such cases, what may be done? If the victim is identified, then the victim may file an application to the state or to the district legal services authorities for award of compensation. Such compensation, once received by the district legal services authorities, etc., must be properly inquired into, and thereafter adequate compensation by the competent authorities must be provided within 2 months. Further, the state or the district legal services authority, as the case may be, to alleviate the suffering of the victim, may order the immediate first aid facility or medical benefits to be made available free of cost on the certificate of the police officer not below the rank of officer in charge of the police station or a magistrate of the area concerned, or any other interim relief as the appropriate authority deems fit. Earlier, we used to see, especially for the motor vehicle accident cases, private hospitals or nursing homes refused to admit the victims, fearing further police complications. Now, with this section, that is section 357A, such kinds of attitude of the private nursing homes or hospitals have now become completely questionable. That means these nursing homes, hospitals, etc., along with the government hospitals, etc., must provide medical aid to the victims. And that too, this must be done when it is certified by the police or the area magistrate that yes, the victim has undergone victimization. In this regard, we must also consider NALSA's compensation scheme for women victims or survivors of sexual assault and other crimes, and this compensation scheme was created in 2018. As such, we get to see in the case of Nipun Saxena versus Union of India, this is a 2012 case, the court has come to this understanding that a committee must be set up of about 4 to 5 persons who can prepare model rules for victim compensation for sexual offences and acid attacks, taking into account the submissions made by the learned amicus. Now, such committee must also include, as I just mentioned, women members, and the chairperson or the nominee of the chairperson of the National Commission for Women should be associated with the committee. This case also mentioned that in case of acid attack victims, the victims who may also have undergone certain kinds of physical injury, etc., even for throwing of the acid or any other body parts and not necessarily on the face. The deciding authority shall be Criminal Injury Compensation Board, and this has also been directed by the Supreme Court in the case of Lakshmi versus Union of India. This is a 2015 case. Now, such Criminal Injury Compensation Board includes the district and sessions judge, the DM, that is the district magistrate, the superintendent of police, civil surgeon or CMO of the district, who may properly analyze the case, who may see the impact of such victimization of the victims and who may also consider what kind of legal, medical, and financial aid is needed for not only the victim but also for the family. NALSA scheme also spoke about compensation for the minor victims, and this is a very significant development of applying victimology in cases, especially criminal cases in India. As we get to see, in case of the victim who is a child and who is an orphaned minor who is without any parent or legal guardian, the immediate relief or the interim compensation shall be disbursed to the bank account of the child. Now, this bank account should be opened under the guardianship of the superintendent child care institution where the child is lodged, or in absence thereof DDO, SDM, as the case may be. This actually indicates that the compensation or the monetary support that has to be given to the minor child who may have undergone victimization because of the death of the parents, or who may have been seen the parents killed or the parents dying because of some victimization. Such child must have the monetary compensation coming from the bank accounts which are opened under proper state care. That means such bank accounts are not to be touched by other relatives, other adult relatives of the minor victims. However, the scheme also says that no claim made by the victim or her dependents under subsection 4 of section 357A of the Code shall be entertained after a period of 3 years from the date of occurrence of the offence or conclusion of the trial, which means that there is a limitation period for such claim for compensation. But considering that the victim may be a minor, considering that the victim may have undergone deep impact, certain kinds of broadening of the understanding has also been provided, and it says that in deserving cases, on an application made in this regard for reasons to be recorded, the delay beyond 3 years can be condoned by the State Legal Service Authority or by the District Legal Services Authority. The scheme and the rules also provide applications procedure for filing procedure. Now again, this is something which is a very important development for considering victimology as an applied science in the criminal justice system in India. It also suggests that there should be a mandatory reporting of the FIR. The SHO, station officer, SP, DCP, etc. shall mandatorily share soft or hard copy of the FIR immediately after its registration with the State Legal Services Authority or the District Legal Services Authority for commission of offences covered in this scheme, which include section 326A, 354A to 354D, especially the criminal activities which may have been done, bodily injury, etc., sexual offences, etc., which may have been done against women victims, rape offences, that is section 376A to 376E, etc., 304B, etc., 498A, especially domestic violence cases, in cases of physical injury which have been covered in this schedule, etc., so that the SLSA or the DLSA can, in deserving cases, may suo motu initiate preliminary verification of facts for the purpose of grant of interim compensation. This scheme further provides that application for the award of interim or final compensation can be filed by the victim and her or her dependents or the SHO of the area before concerned SLSA or the DLSA, which means that this compensation need not be always filed by the primary victim. Suppose, for example, if the victim is not allowed by the medical officers, by the doctors, etc., to leave the hospital, or if the victim is in a vegetative condition, then who will go for application of filing application for such compensation? Here, this portion very clearly mentions that it is the secondary victims who may also go ahead for filing of such kinds of application, and such secondary victims must be directly related to the primary victims. It shall be submitted in a specific form with a copy of the FIR or the criminal complaint of which the cognizance has been taken by the court, and if possible the medical report, death certificate, etc. must also be attached with such copy for filing of the procedure. Thank you.